Today I'm going to be talking about some of the constitutional issues that have arisen surrounding the United States' cornerstone piece of voting rights legislation, the Voting Rights Act. In June 2013, the Supreme Court issued a decision in the case of Shelby County, Alabama versus Holder, where the court ruled that Section 4 of the Voting Rights Act was unconstitutional. The contentious 5-4 decision eliminated the Justice Department's mandatory oversight of the electoral process in the Deep South. And as a result, many individuals have openly expressed fear that the repeal of Section 4 will lead to the return of Jim Crow and a new wave of voter suppression. Now, in order to understand the constitutional issues associated with this decision, and to understand why the ramifications of this decision are potentially so far-reaching, we must first understand why the Voting Rights Act was initially passed and what the Voting Rights Act was designed to accomplish. Now, broadly speaking, the Voting Rights Act was designed to enforce the 14th and 15th Amendments to the United States Constitution. The 14th Amendment, which granted African Americans citizenship and equal protection under the law, and the 15th Amendment, which banned state and federal government from denying the right to vote based on race, were being systematically violated in many places in the American South. Now, following the end of Reconstruction in the 1870s, many Jim Crow laws arose in the South that systematically denied African Americans access to the political process and effectively denied them the right to vote. And we know many of these instruments: poll taxes, literacy tests, all-white primaries, and the use of flat-out intimidation were widespread in the American South up until the 1960s. In 1965, Congress passed the Voting Rights Act in order to tackle these discriminatory voting practices head-on. The Voting Rights Act contains general provisions that apply to the entire country. Now, Section 2 of the Voting Rights Act essentially restated the 14th and 15th Amendment and banned vote suppression, which is actually physically denying people the right to vote, and vote dilution, which is a more complex concept that involves the use of electoral laws that do not weigh each vote equally. However, and these provisions apply to the entire country. However, the Voting Rights Act also contained extra enforcement provisions that did not apply to the entire country, but rather only applied to places where vote suppression was particularly extreme, the states in the American South. It is important to note that the Voting Rights Act was not the first effort to enforce voting rights in the South. The problems with many of the previous attempts to enforce voting rights stem from what former Chief Justice of the Supreme Court Earl Warren called an unremitting and ingenious defiance of the Constitution. Now, the key word here in Justice Warren's statement was ingenious. Challenges to discriminatory voting practices are fundamentally reactive in nature up until 1965. And this stems from the fact that a discriminatory voting law must first be passed before you are able to challenge it in court. In addition to the reactive nature of legal challenges to discriminatory voting laws, challenging an electoral law you feel is discriminatory is extremely time intensive and cost intensive. You have to gather thousands of hours worth of voting data and often have to deal with unfriendly clerks at the local level that attempted to thwart people trying to get this data. And so, as a result, in the event that discriminatory election laws were struck down, they were often replaced by something equally as bad. And Mississippi Governor Ross Burnett really summed up the crux of the problem. Legislatures can change laws faster than the courts can overturn them. And this was the fundamental problem that plagued voting rights activists through the first half of the 20th century. Now, the Voting Rights Act took a more proactive approach to dealing with this particularly pernicious problem stemming from the difficulty associated with challenging discriminatory voting laws. The Voting Rights Act aimed to reverse the fundamentally reactive nature to legal challenges of violations of voting rights by shifting the burden of proof of discrimination from the plaintiffs, from the voters, to the states that are actually implementing voting laws. Now, Section 5 of the Voting Rights Act established what is called preclearance. Namely, it states that states that qualified for Section 5 of the Voting Rights Act had to clear any changes in voting laws, districting plans, or electoral instruments, no matter how minor, by the Justice Department and prove that they did not have a racially discriminatory effect. This was a dramatic reversal from the previous system, where it was up to the plaintiffs to prove that a certain set of laws had a discriminatory purpose. The preclearance provision provided what the Supreme Court called an array of potent weapons against the evil of vote denial, and allowed the federal government previously unprecedented ability to enforce voting rights in the states. So what states were ultimately selected to be subject to this preclearance from the Justice Department? Well, Section 4 of the Voting Rights Act laid out a formula that determined what states would be covered and what states would not be covered by the preclearance provision laid out in Section 5. The states were subject to preclearance if they met two conditions. One, as of November 1, 1964, the state maintained a test or device designed to suppress minority turnout. And by test or device, the Supreme Court was referring to either a poll tax or a literacy test or some other instrument that was specifically aimed at preventing African Americans and other groups from voting. And the second condition was less than 50% of the state's voting age residents were registered to vote on November 1, 1964, or actually voted in the presidential election in 1964. So if one, a test was in place, and two, turnout in the election of 1964 was essentially 12 points below the national average in any given state, the state qualified for preclearance. They were subject to the Justice Department oversight of the electoral process from start to finish. Now, the states that met these 6 criteria were 6 states in the Deep South: Alabama, Georgia, Louisiana, Mississippi, South Carolina, and Virginia, as well as 26 counties in the state of North Carolina and the state of Alaska. The number of covered states expanded to 9 in 1975 with the inclusion of Texas and Arizona, when Congress renewed the Voting Rights Act and expanded coverage to include linguistic minorities, in these cases, Spanish speakers. The act was renewed again by Congress. The act, which was initially designed to be temporary, was renewed by Congress in 1982, 1992, and most recently in 2006, all using the original coverage formula laid out in Section 4. And so states were still subject to preclearance as long as, well, using the initial formula based on how these states actually voted and the implements of vote suppression that were in place in 1964. And as you can imagine, many lawmakers within these covered jurisdictions felt that they were being unfairly burdened by the preclearance requirement. Shelby County, Alabama, successfully challenged Section 4 and 5 of the Voting Rights Act as unconstitutional. The constitutionality of the Voting Rights Act was initially upheld in district court and the Court of Appeals, which led Shelby County to appeal the decision to the Supreme Court. And the Supreme Court ultimately decided to hear the case. The end result of the legal process was the Supreme Court found Section 4 of the Voting Rights Act to be unconstitutional on the grounds that Section 4 of the Act applied the requirement only to some states, which the Supreme Court called a dramatic departure from the principle that all states enjoy equal sovereignty. The court stated that the nearly 50-year-old criteria used to determine what states qualified for preclearance is inappropriate, given how much the state of voting rights and vote suppression had changed since 1964. And as part of his majority opinion, Chief Justice John Roberts, cited evidence that African American turnout had now reached a level of parity with white turnout nationwide, and in fact went so far as to point out African American turnout actually now exceeds white turnout in the state of Mississippi, one of the states that was originally singled out for preclearance by the Voting Rights Act. Moreover, the poll tax and other devices used to suppress minority turnout were outlawed with the passage of the 24th Amendment in 1964 and had not existed for the last 50 years. In essence, what the Supreme Court said was we cannot punish the sons for the sins of the father. John Roberts and the 5-4 majority in the Supreme Court felt such a strong violation of the principles of federalism were no longer appropriate given how much the state of the world had changed in the last 50 years. And this was the basis of them striking down the coverage formula. And since the Holder v. Shelby County decision, there's been a large discussion, an intense discussion about what are the actual implications of this court case going to be. And as the way I see it, there's two primary implications. The first is which the states that were once covered by preclearance are now able to change their voting laws without the interference from the federal government, without oversight from the Justice Department. And the idea of preclearance was a serious one. The states and the covered jurisdictions actually needed Justice Department preclearance to even move a precinct location, let alone make more serious changes to any type of voting laws or congressional districts or anything like this. And the possibility that states will make use of the ability not to have Justice Department oversight is not purely an academic one. Nearly all the states previously covered by Section 5 of the Voting Rights Act have passed a number of stringent voter ID laws in the wake of the Shelby County decision. In addition, a number of these states have decided to reduce early voting periods and eliminated same-day registration. In essence, enacted a series of laws raising barriers to be able to vote. And many observers, particularly observers on the left, have expressed fear that the Shelby County decision, combined with the passage of many of these new voter ID laws, will usher in a new era of Jim Crow vote suppression in the Deep South in particular. However, some recent political science research on the effect of voter ID laws on turnout suggests the fear of a return to Jim Crow is likely overblown. A number of recent empirical analyses of election data have demonstrated that minority turnout is not uniquely affected by the passage of voter ID laws. Thus far, it has been demonstrated that voter ID laws most certainly do reduce turnout overall, but not in a way that necessarily disproportionately targets ethnic and or racial minorities. But it's important to note that these findings should represent an initial findings rather than a cut and dry fact. A potentially greater concern is the increase of vote dilution through the creation of electoral districts designed to minimize minority electoral representation. What you can think of here is essentially gerrymandering. You want to draw the districts to maximize your own power at the expense of other groups, the other groups here being African Americans in the South. The second implication of the court's decision is that we will likely see the true importance of Section 4 and 5, given that we are likely to experience an extended periods of their absence. It's important to keep in mind that the court did not strike down the idea of preclearance. The court did not rule that Section 5 was unconstitutional. Only the criteria that was used to select states which qualified, meaning that there's nothing stopping, at least in principle, there's nothing stopping Congress from passing a new formula to determine what states would be subject to preclearance. However, waiting on anything in these days in Congress, it's wise advice, don't hold your breath. So it seems to be that we're going to go for an extended period of time without a coverage formula in place, which essentially implies that we will not have preclearance for the foreseeable future. So in conclusion, the Shelby County decision has likely ushered in a new era of voting rights, a new and unclear at this point era what this era will consist of. What really remains to be seen was the degree to which the Supreme Court was correct in their belief that conditions were now fundamentally different than they were in the 1960s. Thank you.
Freedom 101 is made possible by generous support from the University of Oklahoma Alumni Association. Freedom 101 is a program of the Institute for the American Constitutional Heritage at the University of Oklahoma. For more videos and podcasts, visit freedom.ou.edu.